Anyone who's dealt with a vaccine injury have felt like their voices are, stifled, or they're being told that they're liars, or they're, just making up political nonsense. So the aim of this lawsuit really is to target the government actors who were involved in this censorship. And if you read the complaint, about 150 pages long, but that's how much detail and evidence we already have of these government actors from the White House, the CDC, the Office of the Surgeon General, contacting social media platforms like Facebook or YouTube, just continuously with this aggression, phone calls, emails, demands for vaccine-related content to be removed if it might make people hesitate to take the vaccine.
Explain to people listening in what's really at stake here.
This is so much broader than just vaccine injuries. Really, the First Amendment rights for all Americans are on the line with this case. And I think we need to set firm precedent that establishes that this is a constitutional violation. And we want to establish firmly that this can't happen again.
Welcome to the React 19 podcast, where we bring awareness and support to the COVID-19 vaccine injured and discuss the science, research, and laws that affect all of us. Hi, everyone. Thanks for joining us again today. I'm Ann Forty, the host of the React 19 podcast. And today we are going to be talking about something probably everyone listening in is familiar with, and that is censorship. So many of us have been censored over the last 5 years to an extent we would have never imagined even possible. And unfortunately, that censorship, which many of us know, has led to devastating consequences for so many. And here today to help us get up to speed on some critically important court cases regarding free speech is my guest, Casey Norman. Casey is a litigation attorney for the law firm New Civil Liberties Alliance. NCLA is representing the co-founder of React 19, Bree Dressen, in the case of Dressen versus Flaherty. And Casey, thank you so much for joining us today. So excited that you're here.
Me too. Thank you for having me on.
All right. Well, I'd like to talk about several of the free speech cases NCLA is currently litigating and about all the amazing work that NCLA does. I really want to touch on that because I don't know how many people are aware of the work that NCLA does. But I'd like to begin with the Dressen versus Flaherty case, which is not just Bree, it's 5 other people, Ernest Ramirez, Sean Barkovich, Christy Dobbs, Suzanne Newell, and Nikki Holland. Again, these are names that are familiar to many of our listeners. So could you lay out the case, give everybody an overview of what it's all about and where it's at?
Definitely. So we initially filed this case in May of 2023, and we've run into a few delays in the case, but we are moving forward. Basically, the focus of this case is, as you pointed out in the intro, censorship. And each of the plaintiffs that you just named there, including Bree Dressen, the founder of React 19, they've all taken to social media platforms like Facebook, YouTube, TikTok, Instagram, whatever it might be, to try to share their experiences following, the COVID vaccine, their injuries, what kind of treatments have worked for them, instances of hope, just sharing advice and making that human connection during a time that has been really confusing. And I think during the pandemic, especially, people like our clients and anyone who's dealt with a vaccine injury have felt like their voices are, stifled, or they're being told that they're liars, or they're, just making up political nonsense or whatever it might be. And so the aim of this lawsuit really is to target the government actors who were involved in this censorship. And if you read the complaint, which I don't blame you if you don't, because it's about 150 pages long, but that's how much detail and evidence we already have of these government actors from the White House, the CDC, the Office of the Surgeon General, contacting social media platforms like Facebook or YouTube, just continuously with this aggression, phone calls, emails, demands for vaccine-related content to be removed if it might make people hesitate to take the vaccine. Just so much evidence already out there of this. So we are trying to get a court order that acknowledges what has been happening, acknowledges that this is a First Amendment violation of our clients' rights, as well as all these other Americans out there who have dealt with the exact same problem. And I think that kind of encapsulates it in a nutshell.
Yes, and I just wonder, I mean, when people think, oh, sometimes people can think, oh, these are just anti-vaxxers. And I mean, nothing could be further from the truth. Obviously, I mean, you've described it already. I mean, with Bree wanting to be part of the trials or people just stepping up because, I mean, Ernest, he just wanting to protect his son. These people were all in. I mean, true, some people took it because they were mandated, but I think this is a list of people who are just they wanted to be part of the solution. And then, as you also said, these were people, and I don't know sometimes if people understand that this censorship actually did cause death because there was no place for these folks to go. I mean, that the only lifeline they had was with um, the people they found on social media. They tried to go, they tried to reach out to the manufacturer. They tried to reach out to the government. They tried to reach out to their doctors. They had nowhere to go. And then they find their lifeline through social media. And as we found out, right after that first, no, it was the second one. I think it was in the second one in November. After one of the roundtables that Ron Johnson did in 2021, right after that, Facebook went into those groups and shut them down. And so those people lost that connection. So the devastation has been overwhelming. And now, just what was it last week? We just heard Mark Zuckerberg come out and
Mhm.
say exactly what you said. Hey, we got these calls from and they were cussing at us, and it was really brutal. And it's like, oh, okay, well, can you imagine how brutal it was for those that had lost their connection? So and then we had last night. President Biden coming out and saying, "Oh, they're going to stop fact checking on social media, and this is to cover up profits." And it's just like, no, that's exactly what you were doing. And so, okay, so I think we understand the severity and the importance of this case. So if this case, where are we with the case? Or is it ready? Is there a date for it to be heard? Is it in discovery? Where are we?
Yeah, good question. So we were on pause for a while. We filed, as I said, in 2023, and I think maybe some listeners are familiar with a related censorship case called Missouri v. Biden,
Yes.
which was heard in the Supreme Court recently, and that ruling came out this summer. But because it's somewhat related to our case in terms of social media censorship, our case was put on hold for about a year until the Supreme Court ruled on that. So after that ruling, we filed an amended complaint, basically, which added, the facts, more developments that had come out in the media, in the news about the types of censorship that we're dealing with that had come out during that year that we were kind of on pause. And we've also added some individual capacity claims against certain defendants. And that means basically that we're coming after the individual actors themselves as opposed to the government agency that was, acting like the White House, for instance. But instead of just the White House, we're also going after Rob Flaherty, who was a White House senior official. So
And so
that's
who,
right.
I'm sorry, go ahead.
Go on. I was just going to say where we are right now is we're waiting for the government's and the Stanford defendants' response to our complaint at long last. It's going to be almost 2 years since we'll have filed, and we're getting it, we hope, at the end of February. And we think they're probably going to file a motion to dismiss. So we'll respond to that and see where it goes from there.
What? Okay, is there a time limit on how long they can take to respond? I mean, could they go another year without responding? Is there a legal time frame here?
Yeah, there is a time frame. Though the trickiness with our case was because of the Missouri case.
Right,
We were put on pause, so their
right,
deadline was just frozen
right.
in time. And then after we filed our amended complaint, because there were certain new claims that were added, we had to reserve all of the certain defendants. And that's the whole thing you see in movies, like you've got served or you've just been served, sir. So we had to hunt down a lot of these defendants, some of whom were a tad elusive, which is another reason why we were delayed a bit further. But all of them have now been served, and the court has entered an order now setting the deadline for end of February for their
Okay,
answers. So that should
okay.
actually be happening this time.
Is there, if they want to dismiss, so yes, they're probably going to say they want the court dismissed, but on what grounds would they do that? What are they
So
going to look at? What are they going to appeal to?
I can only guess, since they're not going to reveal their strategy ahead of
Yes,
time.
yes.
But looking at the Missouri case, for instance, I think a lot of their arguments is based on this idea that, oh, we weren't actually coercing or forcing these social media platforms to censor anyone. We were just, using our bully pulpit as government to express our opinions about things or, express our policy positions. But it was always the independent actions of these social media platforms and not us. And I think if you actually look at the evidence and you look at the heavy, heavy amount of, kind of threatening, not just kind of actually threatening emails where, expletives are used, the F word is dropped. You have Mark Zuckerberg's recent statements where he explicitly said that there were White House officials calling him up, screaming, cursing, that these calls were brutal, they were frequent. And Zuckerberg himself said, at least Facebook resisted the pressure for a while, and then eventually they did change their policies and start removing vaccine related content or vaccine injury content because of this pressure from the government. So I think, at least our argument, of course, is that the evidence is there. We can see this is not just merely the government expressing its own speech or its own positions. But in Missouri, I mean, they're kind of contesting that and saying, we're allowed to persuade the platforms. We're not threatening them. So I think it's always that line between what is permissible and what is not. And I think that's where a lot of the argument is going to be.
Well, let's kind of move to talk about or just kind of interject that Murphy versus Missouri, which is now Missouri, still Missouri versus Biden, and you can explain the language and why that changed. Let's talk about that because I think it was a confusing case for people, where people thought, oh no, I don't understand. I mean, there seemed to be, I mean, there was 20,000 pages of evidence.
Yeah.
Kind of help us understand what happened with Murphy versus Missouri and why it's now Missouri versus it's back to Missouri versus Biden. Just
Yes.
walk through that with us, lay that out and kind of walk us through what happened there.
So just to start with the name change, the case originally was Missouri v. Biden, like at the trial court level where the complaint was filed. But then it went up on appeal to the Court of Appeals in the Fifth Circuit. And certain names got switched around because it ended up being the defendants were appealing a ruling at the trial court level. So the appellant ends up being the first name. And that's why kind of the name
Okay.
switch happens. So you have Murphy v. Missouri, who's the plaintiffs in the original trial court level. It's
Okay. And
probably
I
not that
guess
important, but
for
that's why
for
the name switch happens.
for people who may be totally clueless about all of this case, just briefly, what is this case about and who were the plaintiffs in this case, if you can do
Oh
that?
yes. Yeah,
Because
that is
some
a much
people
more
might not know
interesting.
anything about what we're talking about.
Yes, that's a more interesting response. So, in this case, like I said, it also involves censorship on the social media platforms, but instead of vaccine injury related speech, there we're dealing with kind of a broader array of speech. You have the states of Missouri and Louisiana, who are both plaintiffs. RFK Jr. is also one of the co-plaintiffs there. And then you have a certain group of individual plaintiffs, including Jay Bhattacharya, who your listeners are probably familiar
Oh
with.
yeah,
But
yes,
yeah,
very
he's
familiar.
excellent.
And Martin
But
Klundorf and was Aaron Carty part of that too?
yeah, he's also
Okay,
one.
okay,
Yeah, so in all of these individuals were basically using social media platforms and their followings on these platforms to contest certain government positions or policies. This could be ranging from the lockdown policies, masking, whether the vaccines were efficient, what the COVID origin was, whether it was a
right,
lab leak or not. So it was kind of a wider range of
right,
speech, a lot of it more politically tinted than Dressen v. Flaherty, which is really limited to vaccine injury related speech. But kind of the same issues there where you're seeing censorship, posts being flagged as misinformation, shadow banning, all because it's content that is not in line with the government's preferred policies or narrative. So in that case, they sought a preliminary injunction. The plaintiffs sought a preliminary injunction, which basically is kind of an early form of relief where you say, we have enough evidence already at this very, very early stage of the litigation, and we want the court to temporarily grant us like an injunction saying, defendants, you have to stop censoring or you have to stop doing this until we get it to the very end of this litigation. You get a final ruling, maybe make it to trial or that kind of thing. It's a pretty rare form of relief. It's considered extraordinary by most courts because you're basically having a court say, before I've seen all the evidence, before we've reached the end, I think your case is good enough that I'm going to give you your relief early. So it
Because there
basically,
was so much evidence.
yeah, there was. I mean, I think it was warranted, but the Supreme Court unfortunately didn't agree, and that's what the argument was all about last year. And that's what the ruling in this summer was about.
And why
Um,
didn't they agree? Do you know, or can you summarize that?
Yeah, I think part of it is, and this is something that I think should be pointed out because the ruling in the Supreme Court was that the plaintiffs in Missouri v. Biden don't have standing for a preliminary injunction, as opposed to just standing in general, like to bring the case in the first place. So the Supreme Court did not say the plaintiffs don't have standing. It was just that the preliminary injunction was off the table. And I think this is because, like I mentioned, it's a pretty extraordinary form of relief.
Mhm.
The plaintiffs have to meet a really high burden of evidence. And the court, I think,
Sure
just
thought
said,
it was there.
yeah, I know, I know, me too. I was disappointed, but it definitely doesn't mean that the case is over. I think, they're very strict with this kind of thing. And I personally think that the Supreme Court did not want to sift through 20,000 pages of
Exactly.
evidence, before they've gone through all the fact finding and gone to summary judgment or trial. The court's like, we're not, I think Amy Coney Barrett said, "We are not truffle pigs snuffling through the dirt to get to all these facts here. You guys have to figure this out. It's too early in the proceedings for us to, sift through all these facts and determine on the merits whether or not you win." And basically, I think she gave a pretty good outline of how the plaintiffs might succeed, down the
Okay.
line. She said, the timeline has to be there. You have to show, the White House was pressuring them at this time, and then the platforms changed their policies right after. Just make it clearer, kind of, that this was the government who are the source of the problem and not just the platforms kind of making their own independent choices.
Right. So now that case continues as Missouri versus Biden. Do you know what the status is? Where are we at with that on the timeline with that case?
So yeah, so the case got remanded back down to the district level court or the
Right.
trial court. And I believe the one of the last things I heard was that they're about to move into discovery, but I think the district court judge had wanted some briefing on how does this ruling in the Supreme Court affect how we're going to proceed forward. So there was some briefing on that, and I believe they're entering the discovery stage now and determining how broad of a scope, of information they can request. But they're gonna, as you said, I mean, there's already a lot of evidence and information out there, and they're about to get a whole lot more.
So
So
could they use Mark Zuckerberg's admission this week on what took place? Can they use current that is evidence in their case? Current
yeah, and I
events?
think you always have to think about, what's admissible and what's not in terms of hearsay. But I suspect they're gonna want to talk to at least a high up executive at Facebook, if not Mark Zuckerberg himself.
Right.
Whether it's through a subpoena or he volunteers to, give a statement or testimony. But it's always best to get firsthand statements. But yeah, because those are public statements, I mean, they can certainly reference them in their briefing. But for the actual trial, I think they're going to want to use, someone's actual testimony stating we were pressured in these ways and this was not
Right.
our independent choice.
So do you have any idea on the timeline on that case at all? Like, are we looking at, 2 months, 6 months, or you just don't even know?
Well, I think based on the volume of discovery, they're going to be doing depositions of all kinds of people in
Oh,
these
yeah.
different government agencies, probably talking to people at Facebook, maybe Google, YouTube executives. So I think it'll be several months before they can, finish up with all of that and then read
Right.
through more, tens and tens of thousands of pages of
Right.
documents. So I'm not sure. I would think end of the year at the earliest, but
Oh, wow. Okay. And
yeah,
so, and where do you think Dressen versus Flattery will fall? I mean, do you have any idea on that?
So we'll see what happens with the motion to dismiss. Like I said, the
Okay.
defendant's response is due at the end of February,
Okay.
and then ours is due about a month after that.
Okay.
And the judge will decide whether he wants to have a hearing and, have us argue before him, or maybe he'll just make up his mind based on the briefing. But I would think by summertime, we'll have some answers as to whether we're going forward and also
Wow.
doing discovery. So it sounds like actually the timelines of Missouri and Dressen might start kind of lining up here.
Right. Um, will the fact that we are going into a brand new administration and these people, aren't currently, will not currently be in their positions or any of that. Of course, that could be the case already with some of them. Um, does that affect the case at all that these people no longer have these positions? Would that affect the case at all?
I will see, and I say that for a couple of reasons. One, because we're not just suing these defendants, government officials in their official capacities, which is kind of purely the government aspect of it. But like I mentioned in the amended complaint, we're also suing certain individuals like Rob Flaherty in their individual capacities. So even if the official capacity claims maybe get settled, maybe with people like RFK or Bhattacharya who are leading these agencies, maybe they'll settle the official capacity claims, but we'll still have these individuals to contend with and kind of pursue, who can still be on the hook for the actions that they, conducted in the past in terms of censoring and suppressing. And we're also, I should mention, Stanford University is another defendant in this
Oh,
case.
right, right.
So they, I guess, depending on what the new administration does, maybe if they own up to all of this and they say, hey, these were First Amendment violations, we did work with Stanford and they were a part of this, they conspired, then maybe Stanford would,
Maybe.
back out. But
So
we'll have to see.
do you think having a new head of the DOJ will make a difference?
I think it will. I mean, we'll have to see how this all plays out. I think it'll make
Right.
a difference possibly for the government, the official capacity claims, like I said. But for a lot of these guys, since they don't really fall under the government's, protective DOJ umbrella anymore for some of these claims, well, I guess we'll have to kind of bifurcate. But I'm hopeful, at least, I mean, the government, depending on what they do, that could really impact what the other defendants do as well.
And having said that, explain to people listening in what's really at stake here. Like what is really at stake here?
I mean, I think this is so much broader than just vaccine injuries. It's awful. I mean, what happened to anyone who suffered that or who lost a loved one, like Mr. Ramirez, from it. But I think it's really easy to imagine in different contexts, something like this happening in the future. This could happen to you, to me, whenever the government chooses
On
that,
any
you know,
topic,
yeah, on any topic that's disfavored or that's
right?
counter to the government's preferred positions. Um, I think this poses a danger to everyone, and I think we need to set firm precedent that establishes that this is a constitutional violation. And in the future, if something like this were to happen to someone, they can point to that and say, "Hey, you were out of lines. Like this ends now." And right now, since we're in this gray area with, I think because social media is so new and we haven't really been able to pin this type of censorship on government actors until really recently, there's not a whole lot of precedent that's right on point that says this is unacceptable. You cannot engage in this conduct. So I think really the First Amendment rights for all Americans are on the line with this case, and we want to establish firmly that this can't happen again. And if it does, you point to that and you say, "Hey, you've clearly crossed the line in this. There's no debate about it."
Right. It is so, I mean, just what I've seen over the last 5 years. I mean, I was personally sent, I mean, I'm not vaccine injured, but anytime I would post, it was taken down. I was taken off YouTube. I was taken off video mail and Facebook. And all I did, was posting stories. That was it. It was just
Right.
somebody, I wasn't going after any government official. And so, I mean, which is nothing compared to those who lost their lifeline to this. I'm sorry, I want to go back again to this issue of standing because somebody that I've um, had quite a few conversations with has said this issue of standing literally is destroying our right to redress. Like, apparently, and maybe you can make it more clear that a judge can just kind of decide, oh, well, I don't really think you were affected by this, so therefore I'm throwing this case out. I mean, can you expand on that a little bit? Because it was really confusing.
Yeah, so in theory, standing basically means that a plaintiff has to show that one, the plaintiff suffered harm, that the harm can be redressed in some way, whether that's an order from the court saying to the defendant, stop that conduct because it's an ongoing problem, Or in the case of seeking damages from a defendant, for the harm, you have to show that you have the right defendant. Like this is actually the one who harmed you. So it's kind of basic principles like that. Like, do you have the right parties here? Is your claim ripe? Like, did you actually get harmed? And is that the right person? In theory, it's simple, but when you have cases like this, where we were seeking injunctive relief, which basically is an order saying to all these defendants, you need to stop censoring, you need to stop pressuring or working with third parties to make sure that certain viewpoints are suppressed. It's hard, like in a context where we had a pandemic and supposedly it's over, there's no more emergency. So I think defendants in the government can easily say, hey, we're not, even if we did that in the past, we're not doing it anymore because there's no
Oh,
pandemic. So we're not doing this, and there's no point in making an order, telling us to stop actions that we're not actually doing anymore. And I
yeah.
think that often is an issue in standing when you have First Amendment cases like this, where you can't necessarily prove at the get-go that they are continuing to engage in certain contact or conduct. Um, and I think that was part of what Justice Barrett said in the Supreme Court ruling in
Okay.
Missouri. It's
And
like,
in that particular case, and again, earlier you distinguished between that case and then the the individual cases.
right.
So yeah, it's what is the goal? So with Dressen versus Flaherty, um, what is the what's the conclusion of that? So what are the plaintiffs seeking?
So that's a perfect question. We're seeking injunctive relief as one of our claims for relief. So we do want an order that, like in declaratory relief, which is basically the judge saying this was unconstitutional, this violated the First Amendment, you cannot engage in this conduct in the future. We contest that this is like, a thing of the past. The clients, all of the clients in our case have continued to be censored,
Oh,
up
for sure.
to, yeah. I mean, as you know, you've spoken to all of them.
Yep.
It is definitely an
I
ongoing
just I
problem.
put up a video for React 19, well, which would be and it was taken. This was just I don't know a month or two ago, and they took it.
Mm,
They said it violated community standard. It took one
right.
hour, and other people, yeah, no, it has certainly continued. Not to the extent that it was, where we had to be talking in code and put little carrots or cupcakes or whatever,
Right.
not to that extent, but you can almost even tell within your own posts where, one of your posts maybe where you're talking about, oh, my daughter's bridal shower, and there's a bazillion views, and then you put something up about,
Yeah.
censorship or back, and it's like nothing. And so
Yeah. Shadow
it's just,
banning.
yeah, it's just very, very interesting. So tragic. I mean, just, and I think if with all of this, with vaccine injuries, with the censorship, um, I think if the general population really believed it to be true, we would have a much different response. And it's this, people are still hanging on to, oh, I don't know, somehow the gods of truth live at the FDA, the CDC, and the NIH. Oh, that could never happen. Oh, our government would never do that. And to
Right.
break through that paradigm, I mean, to people for really to have a paradigm shift, I mean, and that's what needs to happen. And I think that's why it's so important that everybody keeps speaking out. In fact, that's what I was going to ask you. What would you encourage people to do who are concerned about this? Is there a way that they can, should connect with NCLA, or, what can an individual do? Contact their
Yeah.
senators? I mean, tell us how to change this paradigm.
I mean, I think, yeah, contacting your senators, contacting politicians that you think can help. But if you want to contact people like us, our website is nclalegal.org. We're always happy to speak with people on the phone or email. If anyone's aware of, censorship or rights being violated, we are open ears. Here to help. We're nonprofit. So, I mean, that's our main purpose is really giving people the opportunity to be able to push back against this kind of thing. And litigation is so costly, it takes so long, and I think most, normal people can't do it. They just have to fold when the government, who has infinite resources and money, decides that, they're going to target you or target what you're choosing to speak about. So,
And I
um,
want to, on that note, I would really encourage people to go check out your website, or the website that of NCLA. There is so much information on there, and your mission. I think I have it. written here somewhere. Or maybe you know the mission itself. It's a nonpartisan, nonprofit civil rights groups to protect constitutional freedoms from violations by the administrative state. And there's a whole little video on if you go to, something about us, our mission, and if you click on the tab, it, lays it all out, what you guys do. And then there's a couple of videos. One is, what's happened over the last 5 years that talks about how it even NCLA came to be, and then what is the administrative state. But yeah, I mean, can you just briefly touch on those kind of cases? Well, kind of say what the administrative state is and why we have to fight against
Yeah.
it.
So, I mean, some people refer to it as the fourth branch of government. Of course, there
Yes,
should not be four. But it is basically kind of the government agencies, federal agencies who are comprised of these unelected bureaucrats, really. And we're seeing just this growth in power of all of these agencies, whether it's HHS or the White House or CDC, whatever it might be. We have so many agencies. I don't even know how many we have anymore. I mean, 300, something crazy. And
it's
there are
crazy. Yeah.
so many bureaucrats within these agencies who are, in essence, making law, determining rights, which of course is not the duty of unelected bureaucrats. I mean, it's Congress who should be making law, but you see kind of the guys in these agencies creating regulations or guidance, various forms of pressure which amount to laws. Coercion, like in our case, you see
Right.
just kind of coercion that's behind the scenes, these private phone calls to platforms, which amounts to people's speech getting censored. But the administrative state, really, for us, is just kind of this unconstitutional wielding and taking and conglomerating of power, where it shouldn't be wielded by these guys who are not accountable to American voters. And a lot of it kind of happens, behind the scenes or without people knowing, because of course they're not accountable to American citizens. They're not actually supposed to be doing these things. And I wasn't even really aware of this issue until, I don't know, the last 5 years. I think
Right.
more and more Americans are starting to see what's happening and wake up to it, but it's been subtle and it's been growing. It's like this creepy monster that all of a sudden is so big that you can't help but notice it. But
Yeah, no, it really, I was so encouraged. I mean, I knew about obviously Bree's case and Murthy, but I don't think I understood NCLA obviously also having a huge win with the Chevron case several months ago. But I didn't realize really the mission of NCLA. And it was, again, folks, I'll put the website in the show notes to this, to the videos about the Dressen case, the Missouri case. I'll put all that in the show notes, but I really encourage you to just almost just to be encouraged. I encourage you to be encouraged that this law firm even exists, and it to see the work that you're doing, Casey, and the whole crew. It was like a relief. It's like, oh, I'm so glad that there are people out there that want to see this and are working towards it and are willing to get behind it. And so I thank you for all of your work
thank
and
you.
keeping free speech free and all the other things. People can check out all the other cases on there too. What about this case did you want to be a part of? What motivated you to be, I want to be part of this case?
I think it's a combination of the things we discussed. First, I think there are really important First Amendment issues here. I think for too long, government officials and actors within the administrative state have been acting behind the scenes, kind of just assuming that they can get away with this kind of thing, suppressing viewpoints, voices that they don't agree with. And I think we have to really firmly establish here for the first time that this kind of action is not acceptable and it can't happen again. But I think people just reading through the facts of this case could really understand just how egregious the government's actions have been here. But also, like we mentioned, I mean, this case is really important because you're dealing with a lot of pain and a lot of suffering and a lot of really good, strong people who are just trying to form bonds, in private often, and help each other. And the fact that this kind of speech, just speech that's pulling people up from the darkest places of their lives and trying to support each other, that kind of thing is being suppressed. I think we've reached a point now where we really have to put our fists down and seriously put a stop to this. And I think that's kind of what drew me in as well. It's not just politics. Not that that's not a value, but
Right.
I mean, this is just all the more egregious when you see people like Bree and Ernest who are being silenced and being told they're liars or, dangerous to society for speaking about what happened to them. So I just wanted to, I don't think I highlighted that enough, but that's
Yeah, you know what? And you're right. I wanted to highlight that as well. I know that was really important to Bree. I know Ernest. I know Bree. I've gotten to know Nikki, Suzanne a bit, Christy not so much, but I obviously know of her, and and Sean Barkovich. I mean, totally. He was so pro-vaccine. He'd get into
right.
fights with his family about, this, and just you know, to be, as he said, we're totally abandoned. Like he was shocked by what had happened. And these lives were because of what social media did, your family turned against you, your doctors turned against you. And as you said, that human element of this is way more than just, oh, you didn't get to say what you wanted to say.
Right.
No, it was it's devastating. That's kind of my byline, of um, just bringing awareness to the unconscionable cruelty that has taken place, and that line comes from Embry in her first or her second. It was November 2021. In Ron Johnson's roundtable, she said, "I'd like to finish with a letter from my friend," and she says, "Bree, please make sure the world knows the cruelty that has been imposed upon us." And that person went off to commit suicide. And
Mm.
that is what you are representing. That is what this case is about.
Yeah.
That is what this is about. And I can't thank you and your team enough for doing it.
No,
Well,
it's
thank
it's an
you
honor.
so much. Again, I'll put all that we've talked about in the show notes, and we will look forward to good outcomes and
Us
hopefully
too.
good judges to see the reality of what's taken place. And we're going to change that paradigm. So,
Yeah. Yes, we will.
all right. Thanks so much. So appreciate it.
Thank you for having me on.
You bet.